2022. The protests were committed in the name of Just Stop Oil about climate change issues. We granted leave to appeal in all cases. The Thurrock tunnels case. In August 2022, protesters occupied tunnels under the roads providing access to the industrial estate, which includes the Navigator Oil Terminal in Thurrock, Essex. Their activities caused the roads to be closed. 4 appellants, each convicted on the 20th of March 2024 of conspiracy to cause a public nuisance, contrary to Section 1(1) of the Criminal Law Act 1977, appeal against the immediate custodial sentences imposed on them on the 6th of September 2024 in the Crown Court at Basildon by His Honour Judge Graham, namely Chris Bennett, 18 months imprisonment, Dr. Larch Maxey, 36 months imprisonment, Samuel Johnson, 18 months imprisonment, Joe Howlett, 15 months imprisonment. The Sunflowers case. On the 14th of October 2022, 2 protesters threw soup onto Vincent van Gogh's painting known as Sunflowers in the National Gallery. They were each convicted on the 24th of September 2024 of criminal damage, contrary to Section 1(1) of the Criminal Damage Act 1971, and they appeal against the immediate custodial sentences imposed on them on the 27th of September 2024 in the Crown Court at Southwark by His Honour Judge Hare, namely Phoebe Plummer, 24 months imprisonment, Anna Holland, 20 months imprisonment. The M25 conspiracy case. Between the 7th and 10th of November 2022, 45 protesters were arrested after climbing or attempting to climb onto various gantries across the M25 motorway. 5 appellants, each of whom was convicted on the 11th of July 2024 of conspiracy to cause a public nuisance, contrary to Section 1(1) of the Criminal Law Act 1977, appeal against the custodial sentences imposed on them on the 18th of July 2024 in the Crown Court at Southwark by His Honour Judge Hare, namely Roger Hallam, 5 years imprisonment, Daniel Shaw, 4 years imprisonment, Lucia Whitaker de Abro, 4 years imprisonment, Louise Lancaster, 4 years imprisonment, Cressida Gethin, 4 years imprisonment. The M25 Gantry climbers case. 5 appellants were amongst those who climbed gantries over the M25 on the 9th of November 2022 as part of the protest that had been organised by the defendants in the M25 conspiracy case. On the 2nd day of trial, the 5th of March 2024, they pleaded guilty to causing a public nuisance contrary to Section 78(1) of the Police Crime Sentencing and Courts Act 2022. They appeal against the custodial sentences imposed on them on the 1st of August 2024 in the Crown Court at Basildon by His Honour Judge Collery King's Counsel, namely Gay Delap, 20 months imprisonment, Paul Susek, 20 months imprisonment, Teresa Higginson, 24 months imprisonment, Paul Bell, 22 months imprisonment, George Simonson, 24 months imprisonment. On the common issues, we ruled as follows. The following central principles could be identified. A. The exercise of sentencing in cases of non-violent protests is to be carried out in accordance with normal sentencing principles, including those contained in sections 57, 63 and 231 subsection 2 of the Sentencing Act 2020. B. The correct approach to issues that may arise when sentencing in cases of non-violent protests, such as conscientious motivation and deterrence, was considered authoritatively in the case of Trowland, 2024 One Weekly Law Reports 1164, to which there was no challenge. The appellant's conscientious motivation was a factor relevant to sentencing in each case. As stated in Trowland at paragraph 55, conscientious motivation falls most logically to be factored into the assessment of culpability. However, conscientious motivation does not preclude a finding that any appellant's culpability is still high. C. A sentencing judge is not obliged to specify an amount by which they have reduced a custodial term to reflect a defendant's conscientious motivation. As a general proposition, a sentencing judge is not obliged to attribute specific percentage values or figures to individual factors which have been taken into account in the sentencing exercise. D. Articles 10 and 11 of the European Convention for Human Rights were engaged in each of the appellant's cases. Article 10 provides the right to freedom of expression. Article 11 provides the right to peaceful assembly. Sentences must not constitute a disproportionate interference with these rights. The common law and the European Convention for Human Rights are in step. If the common law principles are applied properly, the defendant's European Convention human rights should be observed. E. Although the appellant's activities were not at the core of Articles 10 and 11, their acts of trespass or criminal damage were not completely beyond the scope of Articles 10 and 11. Rather, as was stated in Trowland at paragraphs 74 and 75, the fact that the appellant's actions involved criminal trespass or criminal damage significantly weakened the protections afforded by Articles 10 and 11. F. References to the sentencing outcomes in different cases are unlikely to be helpful, since each case turns on its own facts. The sentence imposed in Trowland, on Morgan Trowland 3 years imprisonment, is not a benchmark, and treating it as such risks undesirable and unwarranted sentence inflation. G. It would not have been appropriate for the sentencing judges to have had regard either to the Aarhus Convention or the views of the United Nations Special Rapporteur. We then turned to the sentences in each individual case, and we considered the specific facts of each appellant's case. We have decided as follows. The sentences imposed in the M25 conspiracy case were quashed, and the following sentences substituted. Roger Hallam, 4 years imprisonment. Daniel Shaw, 3 years imprisonment. Lucia Whitaker de Abro, 30 months imprisonment. Louise Lancaster, 3 years imprisonment. Cressida Gethin, 30 months imprisonment. In the M25 Gantry climbers case, the sentence imposed on Gay de Lapp was quashed and a sentence of 18 months imprisonment substituted. The appeals by Paul Susek, Teresa Higginson, Paul Bell and George Simonson were dismissed. In the Thurrock Tunnels case, the appeals by Chris Bennett, Dr. Larch Maxey, Samuel Johnson and Joe Howlett were dismissed. And in the Sunflowers case, the appeals by Phoebe Plummer and Anna Holland were dismissed. Copies of the press summary are available for anybody who would like them. We have made an order in the terms agreed between the parties, reflecting the judgments that we have just indicated, and made directions in relation to any applications for a costs order or for leave to appeal to the Supreme Court. Anything else? Thank you all very much indeed.
Court rise.
Thank you, Martin.